I'm going to introduce the second and the final panel. And this is a panel that's going to talk about recent developments in the dispute financing industry. Tony Seeback is going to introduce the panel. Tony is a law professor at Cardozo Law School and has for the last year, I'm very proud and happy to say, been a fellow at the Center on Civil Justice. And there he has helped our research on third-party litigation funding enormously. Before joining Cardozo, Tony was a professor and associate dean for research at the Brooklyn Law School. And I'm going to ask Tony to introduce the other members of his panel and go for it, Tony. Thank you.
Yes, well, thank you very much, Peter. I want to, first of all, take this time to thank the Center, especially for the opportunity to be a fellow this year. It was really just a fantastic opportunity, and one which I think will continue, I hope, to be an opportunity for committed scholars in academia to help bridge between industry and academia in this area that really needs input from both sides. I mean, eventually maybe also from government as well. This is a field of research where everyone has a lot to offer. It's not just a kind of pure business matter. It's not just a pure government matter. It's not just a pure academic matter. This is an area that affects society in very important ways in which we all have something to contribute. And the opportunity to do a year of intensive work at NYU during my sabbatical was fantastic. Now, today's panel, in fact, following on what I just said, is kind of an extension of the idea that this phenomenon of legal finance is not just going to be shaped by private sector actors, certainly not going to be shaped by academics because no one listens to us, but also it will be shaped by legislative and regulatory entities. And so the panel's about legislative and regulatory developments. I'm going to introduce the panel. I'm going to sort of briefly outline our structure for today. I will give us our code so that you have the code to enter in, and then we'll get into the substance of the material. So in order of alphabetical order, the first is going to be Andrew Cohen, who is a director at Burford Capital. Andrew's actually, in addition to substitute for David Perla, who is also at Burford. David can join us, and Andrew is in sort of generously and at kind of the last minute, I don't know if it's the last minute, stepping in. But Andrew knows the field that David was going to speak about in great depth. And then we also have Dai Y. Chin Feeman, who is Director of Commercial Litigation Strategies, and he's Corporate Counsel at Parabellum. And then we also have Victoria Sahani, who's Professor of Law at Sandra Day O'Connor College of Law at Arizona State University. And we have Eric Schuller, who's the President of the Alliance for Responsible Consumer Legal Funding. I'm going to ask questions like in the last panel. We're not going to set pieces. We're just going to have me ask questions and people answer them. We're going to do that for about 55 minutes, 50 minutes, and we'll go to the next question. David will take you on questions. And now I will give you your code. So everyone take out your pen and get this written down. DFL 349. DFL 349. Okay. So there's been, as always, a variety of different interventions by different public law and quasi-public entities and regulatory entities. As someone who teaches legal ethics, it's always hard to know how to characterize, for example, state bar regulators, how to characterize bar associations. They are not, in fact, typical public law entities. In fact, they aren't really public law entities at all, except by the permission that's granted to them through public law entities such as a legislature or a court. So going through these different sources of guidance and constraint. I want to start off, and we're going to go through like 4 or 5 of these. I want to start off, first of all, with something that many of you may have been following, which is the Bar Association of the City of New York not only produced an opinion with regard to the relationship between legal finance as it relates to law firm capital investment, but then it also followed that up with a response, in some sense, to its opinion with a working group that completed its work earlier this year. So I'm going to ask Andrew and Daiwai to talk about that. Now, I should just also, I suppose, have said that in addition to being an academic, I'm also a consultant for multiple entities that are interested in legal finance. Currently, I serve as ethics advisor to Burford, but that's not in any, I'm not in that capacity today. On the other hand, Andrew is speaking in the capacity of someone who is at Burford, and Daiwai is in the capacity of speaking someone who's at Parabellum. I pretty much could probably, however, try to channel for you what the views of some of the members of the New York City Bar Committee were. I know why they did what they did pretty well. I was in conversation with them, but I won't say anything. I'm going to let them talk about the opinion, but more importantly, the working group's product, and then I'm going to have a few questions. So let's see. Let's go. Let Andrew go first.
Thanks, Tony, and it's good to be here. And thank you everyone for joining in this conversation today. The opinion, the working group opinion, 2008, issued in 2018, essentially said that if lawyers take funding from a litigation funder or any sort of non-recourse funding generally, that violates Ethics Rule 5.4 as it exists in New York State. Similar rules exist throughout the country. This is somewhat of a controversial opinion insofar as there have been numerous attorney funding agreements that have been seen by New York courts and not particularly called out for being unethical. It's somewhat in tension with a lot of other ethics rulings throughout the country, and just threw into some doubt or at least conflict a practice which many New York lawyers have engaged in, and all of whom has thought and after consultation with their own ethics counsel was perfectly fine under the ethics rules. It was a conclusion that we at Burford, I think lots of commentators out there, including our moderator, disagreed with, and there's a lot of ink spilled over this topic over the ensuing couple of years. The basis is Ethics Rule 5.4, which says a lawyer cannot share fees with a non-lawyer, which is pretty straightforward rule. And if you just look at the surface of the rule, I think you can get to the wrong conclusion, which is that it says no sharing fees, therefore no sharing fees. But then you really have to sort of peel it back and say, okay, well, what does that actually mean? And when you do that, you look at the intent of the rule. It is in a section of the ethics rules that's about that also relates to non-lawyer ownership of law firms and general independence of lawyers and the ability to give independent counsel to clients. And when you look at that, then you say, okay, well, how does sharing fees affect that? And the intent of the rule is to preserve attorney independence. Fine. Then you say, okay, well, there are lots of other situations where attorneys are able to share fees. Clearly, once they receive fees, they can pay their bills with those fees. So at some point, fees become from revenue, which is usable for any purpose. And the question is, okay, well, what point is that, and where does the litigation finance sort of interact with the general ability of law firms and businesses to use their revenue? And then you sort of also look at the way that the industry has, you know, the litigation finance industry and the industry of law as in general has moved forward. It is a strange artifact of Rule 5.4 that attorneys are the only group of business people under this interpretation of Rule 5.4 that would be unable to, for example, factor contingent receivables. Any other business can take an asset that is, you know, expected to produce you know, revenue in the future and factor it. Businesses do this all the time, and the calling out of attorneys for this ethical rule, which is not serving the purpose that it is actually intended to serve, to prohibit them from engaging in this activity, you know, really inhibits the development of price law.
Andrew, can I interrupt for a second? Because I want to ask you a question, and I want to jump over to Daiwai as well, which is, to you, I want to ask you the following question, which is, taking this as a regulatory development, can you briefly explain what, in your opinion, is the payoff of an opinion like this from the New York City Bar Committee? And then with Daiwai, what I want to ask is, what is the payoff, so to speak, of what the working group did? I want to know, like, what can people expect in the future? It's, for example, why should anyone care about, I mean, you're right, let's say, about the strangeness of the opinion. You might be wrong, but in some sense, from a regulatory point of view, who cares?
Well, short answer of who cares is people observing the space care, but it is not presidential in any way. The New York City Bar Association has no rulemaking authority, which is fine. They can give their opinion just like anybody else. What it did was it threw some cold water and jitters into the industry, in an effect really not touching most people, because, you know, most of the folks we dealt with did their own thinking about the issue and said, well, this doesn't really have any impact until a New York court or the rules change, which they haven't yet. But then, of course, they threw it over to the working group. So let me throw it to Daiwei to talk about that.
Sure. Before that,
I think you have to volume and go up a little bit.
Maybe I'll just get closer. Can you hear me now?
Yeah.
Okay. In terms of who cares, so there were certain groups of lawyers who did care. We certainly had some deals in our pipeline where this became an issue.
Can you explain why precisely? Is it because someone says this is an accurate prediction of whether or not I'm going to be disciplined?
That's right. It's the type of thing where, you know, not everything.
No one has been disciplined in New York for doing a legal finance deal with a law firm and a capital provider, right?
Not to my knowledge.
Yeah.
But for the genre of things that law firms need to get ethics opinions for, their radar and their antenna is up. And so this was a way, this caused some concern that what they were doing was potentially not permissible and would get them in trouble one day, or it alternatively provided a way to renegotiate terms, or, you know, perhaps inject more adverse selection into the equation. Investors also cared to the extent they were underwriting an investment in a litigation finance portfolio. They said, well, your business model is shifting towards portfolio like everybody else's, away from single case. Is that something that's going to be jeopardized? And if so, how is that going to be handled going forward? So there was some level of caring, but it diminished over time as nobody got in trouble, as the working group was formed, and as things started trickling out about what the working group was thinking. So when the working group was put together, David Perla, who is not here, we'll just call him Andrew today. Andrew and I were on that working group. We're the two litigation funders on it. We were involved. It involved a lot of evenings at the city bar eating popcorn as those meetings are handled. And there really wasn't a dispute in the working group as to whether or not lawyer-directed litigation finance should be permitted. It was just, if we're going to permit it, how can we change the rule or propose to change the rule to allow it to be permitted while ensuring that the underlying policies behind the original rule are not offended. So that was the process that we undertook. So the working group addressed a number of things. The two main areas were ethics and disclosure. Disclosure I'll address briefly because it is a topic of some attempted regulation or regulation. There, the working group came out consistent with prevailing case law and common law trends that disclosure shouldn't be allowed absent special circumstances. It's pretty straightforward. There was a robust discussion of the pros and cons of the various arguments regarding disclosure. There was some disagreement. If you read the report, you'll see it with respect to class actions and MDLs. What level of disclosure is required there? Why? When disclosure must occur? And there's.
Wait, back to your question, why was the working group even? What were they doing? They were just giving their opinion about what the Federal Rules Committee should do, or what the state of New York should do with its own state class action laws?
That's right, essentially. You know, as we're thinking about this.
That's not an ethics issue. That's an issue of civil procedure.
Correct. So the working group was formed to study litigation funding. So, well, 2018-5, the opinion addressed only lawyer-directed funding and Rule 5.4. The working group itself also addressed single case funding, which I think 2018-5 explicitly said was not at issue under Rule 5.4 analysis. So the working group addressed far more than just ethics and lawyer-directed funding. But on the ethics side, there wasn't really a dispute until we started putting together what the various proposals would be. And we actually took a vote, and we're evenly split between what were proposals A and B. And they, you know, both recognize, and the report as a whole recognizes the legitimacy of, you know, or the useful purpose of lawyer-directed funding. Says it's something that should be allowed. So, you know, being of the jurisdiction that it had, the working group did not have a mandate that allowed it to walk back its opinion. So it issued recommendations that were consistent with this opinion because the opinion was based on 5.4 as it currently is. So the proposals to change it were consistent with the mandate that did not allow the opinion to be retracted. So there were competing proposals, and they had different features. One is kind of more restrictive than the other, but you know, it served a good purpose to answer your question, which was to flesh out the different competing interests here, to flesh out the reactions and various stakeholders' arguments in reaction to 2018-5, and to facilitate an intellectual dialogue about how things should change going forward. Now, I don't think that people on the working group necessarily believe that either proposal A or proposal B will be adopted. That would involve its own procedure involving OSAC, as you know. But it was a way to put out there, first of all, you know, to stamp the approval on the practice and say that it's overall a good thing. And to second, you know, flesh out what a change might look like going forward.
So I want to ask Andrew and Daiwai both to weigh in on the following indisputable fact. You both, I think, were in favor of proposal B. No one here is speaking out in favor of proposal A. I could speak out in favor of proposal A and pretend that I think it's the right way to go, but rather, just for our audience, could you explain why the industry preferred proposal B, and how different are proposal A and proposal B? Remember, the vote was, I think, evenly split in the subcommittee, right? Or was it the working group overall? I can't remember if the subcommittee split or whether the whole working group split. It was a 50-50% vote.
Yeah, I don't remember the subcommittee. For everyone's benefit, there were different subcommittees within the working group: ethics, best practices, disclosure, and consumer. But overall, the group was split, and the City Bar Professional Ethics Committee itself, I think, overall preferred A, but generally it commented that, you know, we don't necessarily prefer A over B. We'd like to pick and choose and kind of create a combination.
Right. So why did you prefer B? Or Andrew, why did you prefer B?
I mean, I think B adequately protects.
What was the difference in A and B?
The difference. A requires written informed consent from the lawyer's clients before they enter into litigation funding agreement. B allows for. I mean, the major difference is B allows for you know, a waiver in an engagement letter. This doesn't require, you know, specific written informed consent with any agreement. There were other you know, small differences between them. You know, I think that
I don't think B was a waiver. I think B basically said you just have to inform and if the client doesn't like that, they can go shop for a new lawyer. Right.
But the way that would typically be done is, you know, just as lawyers typically disclose the fact they may obtain funding or you know, standard bank line credit and disclose general information about their cases. That kind of clause is typical in engagement letters. Same type of disclosure would be sufficient for the purposes of Rule 5.4.
Although, and now if I were to sort of be channeling the voice of someone who liked A better, I would just say this. It's not exactly the case that law firms have to tell their clients today that they are going to go out and secure recourse lending for their own law firms, right? The only time law firms have to get the advance consent of their client in the retainer agreement is when they go out and get recourse financing on behalf of the client, for which the client will be responsible. Although, of course, the law firm may treat that as an expense which they may themselves forgive, right? So right now, a law firm, if they want to go borrow $1 million from Citibank, doesn't have to tell their client that they're doing that in the retainer agreement. It doesn't say, by the way, we might be doing, never had to tell their clients that they were borrowing money, right?
Right.
But B says that legal finance companies have to tell their client that we might be going out and factoring our unearned fees.
Yeah.
And what the critics who like A said is that's a halfway solution that doesn't make any sense. If you're going to tell the client, you might as well give the client control over veto of whether you do that or not. Just tell them, because telling them is a peculiar thing. You don't do that now with recourse lending.
Right. Well, I mean, I would throw that right back at them and say, listen, if you don't think that clients need to know about the recourse lending, and by the way, recourse lending can get a law firm just in quite a lot of trouble too. There's splitting up non-recourse from recourse lending in this way isn't really intellectually fair.
Yeah. I guess I'll take the moderator's prerogative by observing that I personally prefer B over A, but there is a problem here of it's not quite a principal distinction. It's kind of like a kludge. And
Sure.
I think was it just simply just a compromise that they just sort of split the baby?
There may have been an aspect of that, trying to get consensus and bring things together. There are different problems. I think that the funders thought that B is adequate and A had certain aspects to it that would create confusion and lawyers would be confused as to how to comply. So for instance, informed consent. Let's say I have a portfolio of contingent fees. How do I get clients informed consent? What constitutes sufficient explanation of the material risks of this and the benefits and the alternatives? Well, if you have 20 cases or if you have 2 cases, it might be different. Who knows? To what extent do you need to, if it's cross-collateralized, to what extent do the lawyers need to communicate to the other clients details of the other contingent representations? To what extent would they have pressure to violate Rule 1.6 in conveying those risks regarding the other portfolio? Because the collateral of the portfolio is important vis-a-vis how each case's recovery is treated and how much of it is distributed to the funder via the waterfall. So it just seemed very difficult. And if things like conflicts can be waived on a prospective basis, it seems that this could also occur. The next point, which I believe strongly in, is that one of the largest categories of consumers of law firm finance are plaintiffs' firms. Their firms are 100% contingency, and they have a choice: recourse or non-recourse. It's effectively the same thing, putting aside, maybe some personal liability, although that can be tricky, or the furniture and the computers. So it's really artificial and not consistent to be keep subjecting non-recourse funding to these additional hurdles.
So, I mean, we could go on forever about this. As you know, it's one of my favorite topics ever in the world. But it is true that this is all just a fantasy, right? Because no one really believes that COSAC is going to pick this up, and it's never going to be passed. It's fantasy legislation. On the other hand, Eric follows real legislation. It turns out that people do actually argue about legislative language that can be enacted and enforced. So I want to move to the next topic, which is state legislative activity. Eric, what's been happening recently in terms of places where real legislation gets passed and real consequences flow from the passing of legislation?
Currently, there's about 11 states that do have something on the books. We had in 2019, Nevada passed a statute which requires a very stringent licensing requirement for the consumer legal funding. It does have exemptions in there for it only covers transactions of $500,000 or less, and a rate restriction on the industry of 40% plus a one-time up to $500 document prep fee. Utah passed this year the latest one, which has basically a registration process with the state, has no rate restrictions, but again, it only covers transactions of $500,000 or less. The trend has been going towards a modified registration process, at least. In other words, who's operating in the state, let's get some basic information on them, things like that. What's becoming a pattern in the last few pieces of legislation that have passed is a reporting structure back to the state. So in other words, number of transactions that are done, what are the rates that are charged, what are the loss rates that the companies have. So in this way, the legislature could take a look at the issue and say, okay, are consumers being gouged by these companies, or are these legitimate rates that are viable for the companies to operate in the states? We do have 2 states in which the rate restrictions were draconian, that basically eliminated the industry. One, which was passed in 2018, West Virginia, which capped the rates at 18%. West Virginia also had a double whammy in which required mandatory disclosure of the contract. And then previously to that was Arkansas at 17%. Right now, the states are basically almost split a little bit more towards non-rate cap than rate caps.
So wait, Eric, you're distinguishing between draconian and non-draconian rate caps. How many states total have rate caps?
Right now, there are 5 states right now that have rate caps in them.
So 2 draconian and 3.
And 3 non-draconian.
Yeah. Okay. That's like little dragons, not big dragons.
Yeah. Right.
And where do you draw the line at draconian?
Where the companies can't operate. I mean, when you have a rate of 17% or 18%, and especially some of these smaller players in the industry, some of them, their cost of capital is between 15 to 20%. So if your cost of capital is at 15% and cost of doing business is at 10%, you're at 25%, and you can only charge 18%, you're losing money right out the door.
Yeah, so the 3 that are not draconian, could you name the 3 that aren't draconian and what their rate?
Yeah. So in Tennessee, it's basically at a 36% plus a 10% fee, so basically a 46% rate. In Indiana, it's at 36% plus 7%, so 43. And then there's an additional up to a $500 document prep fee that can be charged per legal claim. So that can be spread over multiple fundings at $500. And then the last one is Nevada, which is at a 40% rate plus a one-time document prep fee of $500. So that can only be charged one time during the entire legal claim, up to $500.
In addition to the rate cap, there are 2 other, I think, major sort of tools, and you could either call them a tool or you could call them a hammer or a weapon, I suppose, depending on your whether you're for or against legal finance. One is disclosure, and the other one is the limitation on the legal finance company to securitize its asset. Could you talk a little bit about those 2?
Yeah, so there are 2 states in which have the disclosure on it, Wisconsin and West Virginia. And in both instances, it's pretty much identical language. It basically says the party in the case, so it's not up to the funding company to disclose it. It's the party in the case shall disclose, and I'm just paraphrasing this, anybody who's going to receive profits out of the settlement has to be disclosed. And that's the interesting thing. It just says has to be disclosed. It's not real clear as to who that disclosure is to. whether it's just to the other party, whether it's just to the courts. It just says it will be disclosed.
Now, wait, is there a difference between those two states in terms of what is the scope of the regulation? Because my understanding is Wisconsin includes any funding agreement, whereas West Virginia includes only consumer funding agreements.
Right. I was just going to give that. West Virginia, again, only requires covers transactions of $500,000 or less. In Wisconsin, it's any and all transactions.
But it's not just the funder; it's the agreement itself, right?
Right.
Yeah.
Right. But it's the onus is on the party to do it, not the funder to disclose it.
So let's get to my favorite. I mean, of course, no, my real favorite is in these these draft legislations, which are coming out of a certain building in Washington, D.C., is the prohibition of mandatory arbitration, which, of course, as we know, mandatory arbitration is something which corporate America opposes all the time. But in any event, so a lot of these bills say that the funders can't demand mandatory arbitration, even though AT&T can. But let's ignore that one, okay? Let's talk about the securitization, because that's a crafty little move right there. Why does these draft legislations, why are they so obsessed with preventing a legal finance company, a consumer legal finance company, from securitizing the asset? And what does that mean?
What the statement's being made is primarily by the opponents of legal funding, such as the U.S. Chamber of Commerce. What they're putting forward is they don't want the legal funding industry to turn into another mortgage-backed securities where it's crashing, where you're selling fictitious paper out there and it brings down the marketplace or brings down the court system. That's their logic behind doing it.
But since nobody is doing that, and as far as I can tell, no one will do that in the near future, why would the proponents of legal finance, for example, maybe you, care? I mean, why not just let it get into the bill then? Why does anyone care about a restriction which deals with a phenomenon which doesn't occur?
Because of the original way the bill was drafted. So I'll give you an example is Tennessee. The original way the bill was drafted and the original language actually not only prevented securitization, it also prevented the companies from getting money for themselves and putting up
from borrowing money.
From borrowing money.
Okay, so let's get that. So basically, it says that you cannot use a contract for a recovery in a contingent award as collateral for a loan that you might take out from a local bank. So
right. So yeah. So give you just a quick example. Let's say you have a manufacturing firm who has $1 million in receivables and they need $50,000 to make payroll. They can go to their financial institution and say, okay, I've got $1 million coming in. Can I get a line of credit for $50,000 based upon my $1 million? Sure, here it is. What the original bill in Tennessee did was said, no, you can't do that. And we're in the legal funding industry. It was the only industry in the entire state of Tennessee that was prevented from getting money. So the original purpose behind it was to harm the industry, was to basically cut off and choke the funds that the companies have to get money for themselves to put more money out.
So how many states have adopted a provision that does precisely that?
West Virginia has it in there. Tennessee has it in there, but we went back and corrected it in Tennessee a couple of years after that. So now it opens it up so companies can get money to do that. And then Nevada has something very similar to it, but it's, I'm sorry, not Nevada, Vermont. But it's in such a way it's worded so the companies now can still get money to operate. So that chokehold has been eliminated.
Okay, but they still can't securitize and turn them into collateral debt obligations, just like in 2008, something which, as far as I can tell, none of them have been trying to do. But
right, and so with the idea of selling it off and someone else taking over it and running the program, that's not possible.
So it's another example, I suppose, of legislatures choosing to address a problem that doesn't exist, which is one of their favorite things to do, rather than deal with problems that do exist. So this takes us to our next area, which is Victoria. going back to, in some sense, to what Andrew and Daiwai were talking about, if you are going to actually change change the soft law that controls what lawyers can do with regard to legal finance, you would want to change the rules of professional responsibility. That's hard to do. But I gather some Western states are thinking of experiments, like temporary experiments to let, like, is it like Rumspringa or something, which is the Amish do? You get a year to like play crazy and then it goes back to normal or something?
Sure. Well, thank you, Tony. And I would love to talk about that as I'm seated here in Arizona. If I may to make two quick comments about what Eric shared with us, and then I'll turn to your question. The first quick comment is, I think when you talked about draconian sort of rules, I would also include in those the states that have deemed litigation funding alone subject to usury caps when those usury caps are very low, like Colorado, where they said it's a loan and the usury cap is 12% and the industry can't operate. So I would actually include those in the draconian designation as well. And then one other thing is just sort of a thought experiment. As Eric was mentioning many of these statutes, you notice that there was a threshold of 500,000. And the 500,000 threshold is the amount of money that the funder expends to pursue the case. Well, that threshold is based upon current or prior expenditures with respect to funding. On the previous panel, we talked about how with the COVID-19 and the changing world dynamics, there's going to be less travel and less other costs. And so in theory, the cost of funding might go down. And so I'm curious as to whether at some point we might have a situation where a commercial, what would ordinarily be a commercial funding venture, is actually under one of these caps or one of these thresholds, such that it actually gets lumped in with the consumer regulation, you know, to the extent that the remote processes make things cheaper. Just a thought, just sort of a side thought. Okay, so turning to Western states, yes, so we are sort of a laboratory of innovation out here in the West. In particular, the states that are kind of leading the charge on this would be Arizona, California, and Utah. Although there are others that are experimenting, like New York has some proposals in the recent working group report, but they aren't yet implementing anything. One thing I should say before I start talking about the Western states is, where is this coming from? So Rule 5.4 of the Rules of Professional Conduct, as you all know, is the rule that restricts non-lawyer ownership of law firms and non-lawyer fee sharing, right? Well, we know that pretty much universally every state had adopted some version of 5.4 to prohibit this, with the exception of Washington, D.C. Washington, D.C. never adopted the original 5.4 that everybody else adopted. They adopted their own version, which to some extent was not as restrictive and in theory would allow some of the types of structures that would be conducive to funding. We haven't seen a lot of funding in DC. I do think DC's 5.4 rule is still pretty restrictive. It's not fully open. But what we're seeing in Arizona, California, and Utah is pretty wide open here. So I'll start with Arizona because that's where I sit. Arizona's proposal is to eliminate Rule 5.4 completely. So this is kind of a radical proposal.
But I thought you have a sandbox proposal.
Right, but the sandbox proposal also includes this modification. So this was in the task force's report. So they said that they would, it would be a temporary situation, but in theory, you're moving towards this idea that we're going to take away 5.4 and we're going to take the parts of 5.4 that we need to protect consumers, to protect clients, and we're going to put them in other places in the rules. That's the thought process that's in the task force report. They basically said, and this is sort of what the task force said, the task force ultimately concluded that no compelling reason exists for maintaining 5.4 because its twin goals of protecting the lawyer's independent professional judgment and protecting the public are reflected in other ethical rules which can be strengthened. So that's their sort of policy point. So they haven't done it yet. but the idea is with the sandbox to move toward this world where 5.4 doesn't exist in its current form. And this would be for the idea in Arizona is this is an access to justice issue that not only are litigants having trouble getting access to capital, but also law firms.
So let's say I wanted to move to Arizona
Sure.
and wanted to start a capital investment firm that purchased a share of a lawyer's contingent fee.
Mm-hmm.
My business plan would be that I would be able to rely on this being legal for the future, or is it just that I would be able to do it for a short period of time and only if in each individual transaction I got the approval of some committee?
Right. As of right now, that's the way that this is being implemented. So what they're saying is case by case basis, this is the sandbox you're talking about. We're going to let companies say exactly what you're saying. Right? We propose a business where we're going to invest in a law firm, give us an exemption from the existing 5.4. And then Arizona wants to say, okay, let's see how this works with the goal that we think it's going to work well. And eventually we're going to get rid of 5.4 altogether. So it's sort of
this goes back to something which Eric is pointing out. So who's going to lend me money to do that? Because I can't tell them that I can do it next year. I can't tell them I could even do it for the second deal, right? I got no certainty that my business plan is good for anything other than one ticket to ride.
That's fair. Although I will say there are many different types of investors out there. So you probably wouldn't be able to get traditional bank financing for a small business loan or something like that. But there are other types of entities out there that are investing in litigation. Even, for example, some pension plans, some high net worth individuals. There's a lot of places that can get money, and they may have more of an appetite for risk, given that they have such a large pool of money, they can break off a really small piece. So the institutional investors can say, we generally don't take risk with the vast majority of the assets we have on hand, but we're willing to give you a little sliver. And maybe that's all you need to get started. Or maybe that helps you attract additional funding from other sources like angel investors and whatnot. And I think you could do that. But it would be something where you would have to say, okay, look, I don't know that they're going to get rid of 5.4. I don't know how long they're going to let me operate in this way. I know this is a temporary exemption and they could take it away at any time. And you just have to say that up front to your investors.
And how's that compared to California and Utah?
Sure. So if we take a look at California, California is looking at an idea of amending 5.4. So they wouldn't be abolishing it, not as radical as the thought process in Arizona. But their idea is they would say, okay, we will allow fee sharing in which currently is allowed with a nonprofit organization. They will allow a lawyer to expand that fee sharing exception so that they can share fees with a non-lawyer who holds a financial interest in the firm. So again, they would also have to allow the non-lawyer to own the interest in the firm, which is another modification that they're proposing. The important thing to note in California is they have sort of two alternatives. So they haven't yet decided how they're going to do it. They sort of have two ways of doing it. And so this is sort of one of the ways of doing it. And basically the idea is as long as the non-lawyer can have the financial interest, whether it's ownership or whether it's some sort of financing arrangement, provided that, and I'm quoting from alternative one, provided that the lawyer or law firm complies with certain requirements, including, among other requirements, that the firm's sole purpose is providing legal services to clients, which I think is an interesting, strict provision. That the non-lawyers provide services that assist the lawyer or law firm in providing legal services to clients, and that the non-lawyers have no power to direct or control the professional judgment of the lawyer. One contrast between California and Arizona is this idea of solely doing legal services. In the organization, with whether they're non-lawyers that are owners or not, either way, you're still just focused on legal services, and that's the firm's purpose. Versus in Arizona, you could, in theory, and this is sort of one of the reasons for this, have like a big five accounting firm or consulting firm come in and say, we're going to do taxes and consulting and legal services and everything all in one. Arizona is contemplating something like that as a possibility. California is kind of being a little bit more conservative here. with respect to their language. And then they have an alternative 2, so this is sort of a different way to modify Rule 5.4. And so their idea is you sort of largely eliminate the long-standing prohibition, and you basically say we have a permissive broad rule that allows fee sharing with a non-lawyer as long as the lawyer or law firm is complying with the requirements to ensure that the client provides written consent to the lawyer's fee sharing arrangement. So the written consent is something that also exists with respect to fee sharing under other rules of professional conduct. And so the second alternative is more broad, just get the informed consent of the client, and this allows more flexibility. And so we don't know which way California is going to go, but those are the 2 options that they're looking at.
Thank you. So before we move on to questions, I also want to make sure we don't ignore the very big news out of Minnesota yesterday. It's not technically a legislative or regulatory development, but still it's important. So Andrew, could I ask you to sort of briefly mention or talk the bottom line of Maslowski versus Prospect? It'd just be helpful, I think, if everyone heard about it, because it is fresh off the presses.
Sure, and I'd say it is regulatory because the courts regulate the law. But Minnesota has abolished the common law doctrine of champerty. What does that mean? It means that while litigation funding contracts would sometimes and had frequently been construed by courts as violating the doctrine of champerty in Minnesota and in other states where the doctrine is still active, that is no longer an issue in Minnesota, which means client-directed funding is clearly not a champerty problem. The court was deliberate in its review of the law. They responded to arguments that were raised by the plaintiff here, who was, by the way, this was a consumer litigation finance claimant, but the court took her arguments written by the Chamber of Commerce and dismissed them. In other words, said the likelihood that funding leads to frivolous litigation is not really a problem because funders need to make money and they don't make money by investing in frivolous litigation. The concerns that champerty were meant to address are now addressed by other doctrines, other helpful things like ethics rules that didn't exist in the medieval times, and the civil rules of civil procedure, which also didn't exist in medieval times. And basically, just champerty is outdated, no longer serves a function, and is no longer the law in Minnesota. To be clear, litigation funding contracts in Minnesota still cannot be unconscionable, and litigation funders cannot control the litigations they finance in Minnesota, which is the way that things are in every state where we operate. But it is certainly a step forward in getting rid of the outdated doctrine of champerty.
You remember what the vote was?
The vote in
it was Minnesota court, which I assume is
the opinion was written by Justice Hudson. I don't think there was a list of dissents.
And there was no dissent. I mean, I'm just intrigued by unanimity. I would just observe, and if Richard Painter were still here, he would also be able to observe that, Minnesota is one of the few states, say 2 things about Minnesota. Minnesota is one of the few states where the precedents here are unambiguous. They are revisited frequently over the last 200 years. And this court simply just turned around and rejected the underlying reasoning of the precedents. And I think they had to do so because there have been frequent eruptions in the federal courts and in the state courts because of the challenges to the enforcement of contracts. And I think they felt like this needed to deal with it. You don't see that too often in other states where you have the lower courts constantly dealing with this issue. You did in Minnesota. So that might explain why Minnesota did something that I think is pretty extraordinary. Okay, I'm going to give out the code for the remainder of the session. It's DFL 434. And I want to ask the panel to comment, if they wish, about whatever we should take from the most recent Uniform Law Commissioners dipping its toe into this issue. I think they dipped their toe in and they've taken their toe out. Does anyone want to talk about this? I know
Tony,
many of us have been
if
observers.
Yeah, Tony, if I just real quick on Minnesota, what I really noticed between this decision and the one last year on the Cherokee case in Georgia was the deliberateness of the court. In Georgia, they just looked at Georgia. They just looked at Georgia law, Georgia issues, Georgia. Whereas in this one, they looked at what's happening in the legislature. You know, you were quoted, your paper was quoted in there.
So
and they looked at it.
And so was Victoria.
Yes, and Victoria's too.
Yeah.
So, I mean, they took a really a holistic approach to the issue, which I think is really good for the industry, because I think this is something that could be cited in other states, because the fact of this is a very deliberate, like you were saying before, look at the issue and not something that's just state specific.
I'm already going back to the Republic of Ireland. See if we can finally reverse the Republic of Ireland's prohibition of legal fundraising.
Well, and then back to the Colorado decision, you know, where they said that there were loans. Again, that was specifically just on, you know, Colorado issues, which I think was good in this one. It took a, like I said, big holistic approach on the industry versus very state specific. So I just want to kind of throw that out there real quick.
So does anyone want to say anything about the Uniform Law Commissioner's recent moves?
Sure.
I do think. Oh, go ahead,
Victoria.
I was just going to say, I do think it's interesting because many academics, Tony said, you as you mentioned, you said, no one listens to us. There have been academics that have published on the issue of, well, why don't we get a uniform law on litigation funding? And I think it's great that they at least looked at it. At least said, we'll consider this, maybe not yet. And I think that that's the right approach, given you know, Eric's research and the research that we've all done. The patchwork is just all over the place. I don't think that it would be that there's a clear enough legislative imperative as to what the legislation should look like if it was going to be a uniform legislation, for them to really even be able to move forward. It's just not enough clarity. So I think that's the right idea, that they're paying attention. It's kind of like what the Federal Civil Rules Committee did. People kept saying, well, the chamber kept saying, revise the rules, and they kept saying, okay, we're noticing, we're paying attention. We're not revising anything yet, but we're watching. And I feel like the Uniform Law Commission is saying the same thing. We're watching, just letting you know, but we're not going to do anything yet.
Right. This is their second time that they looked and the second time that they pulled back, right?
Mm-hmm.
Yeah.
Well, I don't know if they've officially pulled back yet.
Okay.
Like there's
a call. Yeah,
there's a call. There's a call pending on it.
Yeah.
But if you look at the statutes that have passed, like I think Utah is a really good example of taking the basics of what's needed. And in other words, just like any financial product out there, and I'm just speaking more on the consumer side of things, is it's nice to know who operates, because I know every time I go into a new state where there is no statute and there's a proposed statute, 90% of the time, the first question I get is, okay, how many companies are operating in my state and who are they? Well, I don't know, because there's no mandatory requirement for it. So having some sort of registration process and having some basic guidelines as to contract disclosures. And when I'm talking about contract disclosures, I'm meaning the consumer knows day one what are the charges going to be, that the companies cannot have a financial, or a say in the settlement process, things like that, which are basic common sense issues. Just put those things through. And kind of a little bit of side note on going back to a little bit something that was done in the first panel, talking about rates. Oklahoma is probably the state that has no rate caps, that has probably the most reasonable rates in the industry. And the reason is because of the uniformity of the contracts. Consumers and their attorneys can look at company A, company B, company C, and the terms and conditions are exactly the same. And what I found interesting is there have been 3 companies started up in Oklahoma since the statute has started. And those 3 companies are literally giving the national players a run for their money, because they're adding that local twist to it. They say, hey, Mr. Lawyer, Mr. Law Firm, we want to work with you. We're right down the street here in Oklahoma City. We're right down the street from here, you here in Tulsa. So if there are issues, we can deal with you and work with you locally. The rates that are being charged right now in Oklahoma are probably some of the most reasonable rates across the country because of that competition, because of the uniformity of the contracts, and consumers and their attorneys know exactly what they're getting themselves into.
Really interesting. So we are at the 20-minute point, and I think it would be good to open to questions, although the panelists are free to talk to each other and ask questions of each other. Direct your hand to David, who can see if you raise your hand on your little Zoom control board, not the applause GIF, but the hand thing where you raise it. So if you want David to call on you, please raise your hand.
I might have
Tony,
missed
could
it.
I
Did
just
you
make-
did you do
Victoria?
the CLE code?
Yeah. I did get the
Okay.
CLE. Yeah.
Okay, sorry.
Tony, could I just make one quick comment since Eric mentioned Utah? Thank you, Eric, for giving me that segue to the third Western state. I just wanted to quickly mention that Utah has a standing order 15, and that's the sandbox that you were talking about, Tony. So that's where they're having that sort of laboratory, and people can look up standing order 15 in Utah.
Any questions for us?
So you can
No,
type
we
it into the chat, or if you click participants on the bottom, there's a hand raise option.
I mean, I have questions, and I'm sure we each have questions for each other, but
Yeah, why don't you go ahead unless someone else raises their hand? I don't see any hands raised.
as you can see, I'm feeling a little frisky because it's like Zoom conferences mean you get to stay at home, and it's a little bit like yelling at the TV set. And I just want to say that I would like Victoria to explain what she thinks all this sandboxing is worth. I mean, isn't it just like the working group? Isn't it just a way to allow people to vent? I guess it's the alternative would be for lawyers to go out in the streets and smash things. I mean, we're not going to actually see any real change, are we? Because the only way to have a real change, in my mind, is for there to be some, and this raises an interesting question, like, what do lawyers really need to know about the risk of discipline? Do lawyers need confidence that the risk of discipline is diminishingly small, or are lawyers comfortable in a world in which they just don't know whether or not, in theory, they can be disciplined, but they don't think it's really going to happen?
Sure. Well, there's a couple of answers I would have to that. One of them is, I would say from the lawyer perspective, there's two pieces. One, of course, is the uncertainty, but the second piece is the malpractice insurance. And so if you're going to be dancing on the edge of the rules of professional conduct, you're also more likely to get sued by your clients, with respect to things that they think violate the rules. And so the uncertainty, I think, is challenging for the attorneys. And I think the sandboxing on the one hand is helpful for the brave out there. There are some attorneys that are very brave and gung-ho and have that Wild West, I'm going to experiment kind of attitude, whereas others are really sort of conservative. And by conservative, I mean they just want to play by the rules, by the book, and they don't want their malpractice insurance to go up, and they don't want to get sued by their clients.
Let me be clear, Victoria, because I want to be clear. I don't want to be misunderstood. I think that with the sandbox, it's obvious that if a lawyer gets a certificate from the committee that the sandbox has been created by Rule 15, you can't discipline them because they can say, listen, I was given this license to do this one deal. But if I'm building a firm or if I'm trying to plan for 10 years and I don't know whether or not I can do anything more than just one deal, then I am going to be thinking to myself, well, if they let me do this once, will they let me do it again? And if they don't, and don't even have to ask, maybe I'll just go do it the next time and not even ask, because if they let me do it once, I can say to myself, I probably won't get disciplined. See?
Right.
I don't see how just getting permission for one deal in 1 year is a practical solution to the problem that a lawyer has or a funder has of what am I going to do for the planning for 10 years.
Right. Well, I think it's even more complex than that, because even if you get the permission to do the one deal, the rule just says you have permission to do the deal. But there's all these other landmines in terms of how you engage in the practice of serving your clients with a litigation funder owning part of your firm. There's privilege issues. There's confidentiality issues. There's issues of control. There's issues of notice and competence. And so it's not just, I got a stamp of approval from the state that says I can do the deal. There's so much, it's so fraught, and there's no guidance on how do I conduct myself. There's a little bit of vague sort of independent professional judgment. Don't let the funder tell you what to do and that sort of stuff. But the problem is it's going to be on those fringe cases where the attorneys could actually end up having a legal sandbox and still get disciplined because they went over the line in terms of their relationship with the funder. So that's, I think, where the uncertainty still comes in. And then you're right about the 10 years. I mean, the future, how do you build your business? I mean, that's an even bigger question. I would say first you have to successfully get the thing off the ground and have it run without getting disciplined or sued for the first 6 months. And then we can look at 10 years down the line.
Any other thoughts? No. So going back to the idea of state legislation. Eric, do you think that there is a kind of coalescing around 36% as the acceptable non-draconian cap? And if so, can that be part of a larger, maybe, I don't know, anything larger, not just in terms of many states doing it, but even perhaps even a kind of a uniform law, or maybe somehow if it could be built into the federal regulatory structures.
Yeah, I mean, where the 36% number is coming from is based upon the Military Lending Act rate on a national basis, which was put into statute federally during I think it was around 2003 to protect service members who have been deployed. And so it's now become kind of a standard number across the board. And several states, Virginia this year enacted last year, and then upped the effective date of it this year to where all loan products are capped at 36%. Where this really doesn't work with this type of product is these aren't loans. I mean, in all the state statutes that have been passed, not a single statute has labeled the product a loan. The only time it's been quote unquote labeled a loan is either by a court action or by an administrative action. And the problem with putting rate restrictions on the product is you're eliminating the risk assessment portfolio of it. So give it a quick example. So let's say you have two drivers, both drive 2015 Ford Explorers. One has had 3 DUIs and 2 speeding tickets in the last 5 years, and the other one hasn't even had a parking ticket in 35 years. Do they pay the same amount for car insurance? No, because the State Farm, Allstate, whatever it is, risk assess those two individuals, saying they're most likely going to have to pay out one over the other. The problem with putting in rate restrictions on the product is you're saying to the companies, you can only take these types of cases that meet this risk portfolio. So in other words, if let's say a company has a case that they wanted to put some money on, through the consumer, but it's a very high risk case, if it's outside of that parameter, they're not going to do it. And then who gets harmed in those things is the consumers, because the consumers don't have that money. Just because you eliminate the product doesn't mean you eliminate the need. So what happens when in states like right now, West Virginia and Arkansas, where the product is non-existent, those consumers that have that need still need to fill that need. So what do? They typically go to out of state, on the internet, high risk financial products such as payday, title loans, things like that, or they end up settling their cases short because the fact of they need money for their rent, their mortgage, their car payments, things like that. So the issue of putting rate caps in it, all it really does is just eliminate who can be helped by the product. And that just really doesn't help the consumers. It doesn't help the marketplace, and really doesn't help the legal system at all.
So
And can I just point out too that the question about maximum rates is really a consumer litigation finance issue. I just want to separate out the consumer issue, the commercial issue. The idea of rate caps applied to commercial litigation finance is sort of just not even in the question. And that's why when we see this kind of legislation coming up in various jurisdictions, we want to make sure that to the extent consumer protection statutes are a good thing and necessary, that's fine. But often those statutes are written so broadly that they would also bring in commercial litigation finance, and we want to avoid that. Commercial entities are capable of making their own decisions, and if they want to sign up for what is effectively a rate that is higher than the usury cap, that's something that we typically allow, freedom of contract, et cetera. That I do also want to respond to Victoria's sort of thought experiment, which is, why is it 500,000? Why not lower? Having been a part of these conversations, 500,000. It's hard to explain sometimes to legislators what the difference is between commercial and consumer litigation finance. And so the way that has worked before is to say, oh, look, there's this other statute where this line is drawn. You can draw the line in the same way. Explaining the difference between, well, maybe now it makes more sense to be 100,000, and frankly, that would be perfect. That would still draw a good line. It's harder to make that additional distinction for the legislature. So it's more a point of convenience than a principle.
So Andrew, going back to your first point, assuming that many legislators who Eric deals with are not just single-mindedly trying to hurt the legal finance industry, consumer or commercial, but they are trying to practically solve a problem that their constituents have told them about, which is mostly the consumer legal finance market feels to a lot of people like it's a bit choppy and needs a little bit more control. Not the commercial market. They probably agree with that. But then they end up writing laws. They end up writing sentences that have to describe this. Have you seen examples of where they're just getting it wrong and they're being overbroad, or they're not actually precisely and capturing what it is that they think they want to do and they don't realize that? Or do you have any recommendations about how you could sort of write a law that doesn't have a ambiguity that later on we go, oh my God, no one thought of this before?
I should defer to the law professors here who've taught the law of legislation, but I think it's tricky, because what is the difference between commercial litigation finance and consumer litigation finance? It's not always necessarily type of claims. You can sort of maybe cabin off personal injury. You can maybe cabin off certain types of claims, but then you're sort of doing an enumeration of all the types of claims that fall under this bucket versus that bucket, and that's ugly legislation.
What about saying that the counterparty is a natural person as opposed to a counterparty is a
no, that doesn't work, because there are sole proprietorships and there are commercial what we consider commercial claims that are qui tam lawsuits that are brought on behalf of individuals. By individuals on behalf of governments. There are cases that are still commercial that fit under that. And so it is tricky. That's why typically we've pushed for the dollar limit. That's maybe it's not the nicest dividing line, but it is a bright line. And we've gotten pushback, I think, from the consumer folks in some cases, where why $500,000? That's too high. We don't want to suggest that consumers are getting loans that big. And we say, fine, whatever we can get to work can work. But I will say, I admit it is a difficult legislative problem, and I haven't found perfect language to solve it.
Let me interrupt for a second. David Siffert, do you want to give a third code now or at the very end of the session?
Either way.
You want to give the third code?
So yeah, why not? It'll be DFL 454.
Okay, I just want to make sure that wasn't sure when you wanted to have the last code. Anyway, yeah, Victoria, you were about to jump in?
Sure. I actually wanted to jump in on what Andrew's point. And this is the definition. It's interesting. We can always talk about rate caps and disclosure and all these things that seem pretty concrete. the hardest part of regulating this industry is the definition. That's the sort of irony of this. I was on a task force for 5 years, a global task force that was analyzing third-party litigation funding around the world in variety of jurisdictions. And one of the things that took us the longest was trying to write a definition. And even then, we had to have footnotes and sort of say our definition is both overbroad in these ways, it's too narrow in these ways. And we just sort of had to come to the conclusion that no definition is going to be perfect. And so well, Andrew's right. I was sort of pointing at the 500,000. I wasn't sort of criticizing it. I was saying, look, it does the job, right? But as the world changes, for example, as we do more remote hearings and things like that, and as the price goes down, or as the amount expended goes down, you know, those 500,000 caps are going to seem too high. And then what do we do? Do we have a situation where we suddenly are regulating commercial financing with consumer regulations, which is not what they were meant for? Do we need to switch to a non-financial definition? And if so, how do we write that? And this is something where I actually think the Uniform Law Commission could be really helpful. Maybe they could come in and try to just do a definition. Like forget all the other pieces of the regulation, let the states do what they want, but at least defining what this is, maybe that's where we need the uniformity. And it's also the hardest to achieve the uniformity in. So.
Well, yeah, on that note, one of the things that has been...
Eric,
yeah.
Daiwai, did you want to?
Yeah, I was just going to say, I noticed in Florida's proposed legislation, what they attempted was to say that litigation financing is not litigation financing if it's a commercial tort claim, which I thought was interesting because that, I think, links to their UCC, which is uniform law. So that's an area that can be addressed. But the issue with commercial tort claims is actually, if you look into it, not everyone agrees what a commercial tort claim is, and there's not a lot of different. So is an antitrust claim a commercial tort claim? Actually paid someone to look into this and gave me disappointing advice. Is a breach of contract claim a commercial tort claim? So things like that. But there was an attempt in Florida, and I thought it was interesting, and I think it could have been done a little bit better. Maybe it will be.
So listen, we're at the 3 minutes to the end, and it's exhausting to do this by Zoom. I think, David, unless you have questions that you would like to call someone on, I feel like we've gotten to a good place to stop, and I'm willing to stop now. You wanted to give a few final words?
I have a couple of words that I would like to give, Tony. First of all, I want to thank all of the panelists. Thank you, Tony. Thank you, panelists. Thank the previous panel and the audience. And I hope that you will use the dispute finance library and also follow the other activities of the center. Sometime soon, David will be sending out a note to all of you. I'm assuming, David, we have everybody's email address. And with both the instructions on how to claim the CLE credit, the forms, and a link to both the dispute finance library and the center website. David, you want to add anything?
I don't think so. I'll be sending I'll be sending out a follow-up email with the video, with the CLE forms, the link to our website, everything you'll need. And we really would love feedback on the site. And if you have documents that you think we should add, we'd really appreciate it.
Okay. So with that, thank you, everybody, and have a good rest of the day.